so we will try and be quite concise. This panel is on the international realm. As everybody knows, at the end of his life, Ronald Dworkin addressed international law, and his article on this subject was finished by colleagues after he died and published in Philosophy and Public Affairs. We have two panelists to address this issue in order. Rob House will begin, and then Julio Montero will succeed Rob.
Thanks a lot, Dick. This has been a very stimulating and challenging 2 days, and makes me want to go back and reread all of Dworkin's main works in light of the many different interpretations and takes on those works that I've heard so far. An apology that I have to leave sometime during the next session because of flights, but thanks again for the opportunity to be here. Dworkin's short essay on international law was published posthumously in Philosophy and Public Affairs, with some editing by my colleagues Liam Murphy and Sam Scheffler. And it's really to that essay that I turn in this short paper. Dworkin addresses international law in the last few years of his life and attempts to apply what I characterize as his moral interpretive approach to law and legal systems to a kind of law that is not embedded in the institutions that provide so much of the supporting context for his theory and others of his works, namely a representative legislature and a high court which is capable of effectively enforcing rights throughout the jurisdiction that pertains to that high court. So how to apply a moral interpretive approach without such institutions? One answer would be that the moral interpretive approach implies an agenda to build such institutions, a world parliament, a court that, unlike the current International Court of Justice, would have compulsory jurisdiction and possibly, at least in principle, coercive power throughout the world. And towards the end of Dworkin's essay, he seems, to think that even though that's a very distant prospect, it might be an implication, an ultimate implication of the kind of approach he's adopting. I argue otherwise in this paper. In other words, I think that the moral interpretive approach can work with the more decentralized, non-hierarchical, gap-filled kind of international or legal order that we actually have. And in fact, that it probably can work better in the sense that there are certain issues of legitimacy or the meaning of obligation that would become quite pointed if one were to try and develop Dworkin's view in the direction of world government and global adjudication accompanied by universal or putatively universal coercive power. So the first part of the paper addresses several, I think, fairly powerful criticisms that Dworkin makes of positivist accounts of international legal obligation, which, as he says, are ultimately all founded in a notion of consent of states. And The first criticism is that it seems important that international law be able to bind states that that don't explicitly consent, either through U.S. Kogan's preemptory norms, for example, or customary international law. And so if we have no explanation of how a state could have an obligation to follow an international legal rule without its consent, we would not be able to justify some essential features of the existing international legal order. So that's the first criticism. Another criticism has to do with a problem that's actually, I'm not sure Dworkin was aware of this, but which has been pointed out by anti-positivist international jurists, I think even going back as far as Grotius, that you cannot, and it's a version of a philosophical problem that will be very familiar to the philosophers here, it's a problem with all forms of conventionalism, that you cannot derive adequately the obligation to follow conventions or promises that one has entered into from itself from a convention or promise. There therefore has to be at least one kind of moral foundation for conventionalism that itself is not conventional. And so, Dworkin, applies this in the case of, for example, customary international law, and I give what I think would be one positivist response, which would be that, doesn't opinio juris satisfy that norm? It's an agreement among states that you don't have a rule of custom unless states think they're following international law as a matter of obligation, and the fact that they think of it, they follow a rule of custom thinking that they do so as an obligation would be, on a positivist account, probably enough. And so I kind of construct an answer of Dworkin that I think Dworkin might give to that positivist objection to his critique of positivism, which is, well, in fact, it's an extremely messy business to determine what's opinio juris, which statements of states or agents within states count as evidence of following a practice out of a sense of obligation. So ultimately, when you look at the way that courts have tried to ascertain the existence of opinio juris, they've usually done so by employing some kind of conception of the justified purpose of the rule within the international legal system in doing so. And so I use the example of an old case, Paqueta Havana, where Rudy Teitel points out in humanities law that actually it's a very old U.S. Supreme Court case, but nevertheless, even there, the inquiry into opinio juris by the U.S. Supreme Court was very much guided by the idea that the norm in question, non-seizure of innocent fishing boats during hostilities, served a humanitarian purpose of protecting certain innocent people, in the midst of conflict, and allowing them to continue to engage in innocent economic activity. So if this seemingly purely factual exercise of ascertaining whether states think they're following a practice out of an obligation itself can only be rendered coherent by the supposition that there's a certain purpose that the norm must serve within an international legal system, then actually even here we need a moral interpretive theory to direct us to the relevant evidence of opinio juris and sift through the various statements or materials that might be evidence of opinio juris. So that might be the kind of response that Dworkin would make, I think, there. So if positivism, and finally, and this is quite interesting because I work with Ruti, among other issues, on issues of self-determination and secession. And in fact, around the time that Ronnie was writing this, we presented a paper of ours on self-determination in his colloquium, and he had very interesting responses to this. His final critique here of the positivist is that account is it can't provide a defensible notion of continuing legal obligation with government's change. And so that's one of the basic principles of state responsibility in international law. Governmental change does not result in the defeasance of international legal obligation. But why, Ronnie asks, should a government, a future government representing the will of the people, be bound by an act of the people or an act of a government that may no longer represent the popular will? Domestic law can, even constitutional law, can destroy itself. International law, legal obligation cannot be changed unilaterally. That is to say, you would need to have the consent of other states unless the particular obligation has, a self-terminating, a feature that allows it to be terminated unilaterally, such as a denunciation clause in a treaty. So those are the critiques of positivism. And let me quickly move on to the foundations of Ronnie's alternative theory. And here, the distinctive argumentative move, which I'm sure can and will and should provoke a lot of discussion and debate, is to say that ultimately international legal obligation has to be grounded in the same associative obligation that grounds the law, the binding character of the legal system domestically. Now that's a really important and questionable move, because what he's essentially saying is that international legal obligation is derivative from or secondary to domestic political morality, and therefore the question is how you can have a fully adequate concept of obligation that operates at the international plane. But the basic principle that through which Dworkin articulates this view is the idea of salience, that states are, required to cooperate with each other or constrain themselves through international obligation in order to fulfill the requirements of domestic political morality. He gives examples of human rights and security, of the right of citizens to basic security cannot be achieved except through, peace agreements or rules on the use of force between states. Then the demands of domestic political morality imply that the state is required to enter into such cooperation or such agreements. But the ultimate foundation is domestic political, what I would call domestic political, morality. So, what are the implications for this institutionally and doctrinally for international law? Well, first of all, and this is something that Ronnie didn't have the chance, I think, ever to address, of course, there are states that sign international agreements or undertake international obligations that are not liberal democracies, or do not do so based upon the demand, what would be the proper demands of political morality based upon a liberal democratic political philosophy. And so the first puzzle is what would bind them and what would bind us to them in international law. And so thinking about this made me appreciate even more why Kant, in his vision of transnational legal order, had a requirement or condition that for such order, for this to be a genuine federative normative order at the transnational level, each state would have to have what he called a republican constitution, which is to say a constitutional arrangement informed by some version of liberal democratic political morality. But if you still have an international order, where many states do not have that, how adequate is this going to be as an account of international legal obligation? And I think this goes to the institutional dimension, and my comment comment earlier that late in the article that Ronnie seems to be wanting to move towards some kind of world assembly or parliament, towards making an international court have universal coercive power and so forth. But it seems to me that actually, given this difficulty that I just mentioned about the different character of international legal obligation depending upon whether a state is a state that is operating on the basis of an appropriate internal political morality, points to some desirable features of the existing arrangements. For one thing, it points to the value of domestic courts and regional courts interpreting international law, because they can properly and legitimately apply either domestic political morality or the political morality of some grouping of states, that each of which does have, in consensus, a republican constitution. Whereas, and here I didn't cite this piece by Emery Slaughter, it's a piece, Law Among Liberal States, and it's kind of influenced my thinking a bit here. Whereas, there are elements of the existing institutional arrangements that would make sense given that there are other states in the system who are bound in a different way. They might be, dictatorships or theocracies or whatever, and international legal normativity would not have the same relationship to salience in dealings with these states, either among themselves or our dealings with them, and therefore it might make sense in those circumstances to have weaker international institutions where, so that what would an international court do when applying a moral interpretive approach in a dispute between a state that has liberal democratic political morality and derives its international obligations from that morality versus a state that doesn't, and might just think of its international obligations in terms of immediate interest, or actually as something that's kind of imposed on it by the power realities of the international system. Well, if an international court were to use a moral interpretive approach grounded in liberal democratic political morality to interpret the international legal obligation, there would be a legitimacy issue with respect to the state that's not a liberal democracy who's a party to the dispute. But since we don't have an international court that has or claims to have universal coercive power, we don't need to worry, I think, so much about this legitimacy problem under the existing institutions. Now, I'm not meaning to say that the International Court of Justice does not issue binding decisions. They're binding between the parties, but ultimately the state responsibility for enforcement, or for what happens if there's a failure to implement a decision of the ICJ, rests with individual states, including at the limit non-forcible countermeasures. So we still have this decentralized system that many international lawyers bemoan. My question is, can international law, as constructed on the basis of a moral interpretive approach, really bear institutional arrangements that are more like those of the state? And I'm not sure it really can. If the world were to change into a world where every state had a republican constitution, ultimately grounded in what I think Dworkin would consider to be the right political morality, then a different kind of institutional arrangement would be possible for international law, and one could imagine that one could apply the moral interpretive approach in a more intransigent way, which might be the ultimate implication of Ronnie's view here of salience is critical to grounding the moral interpretive approach to international law. Do I have any minutes left?
I'm not keeping that close time.
Okay.
Oh, we can go on
So,
4 o'clock or
so
4:10.
this all sounds very abstract, so I want to refer in the paper to 2 concrete examples of what I mean, where these are examples where in one instance a regional court and in the other instance a national court seem to defy international legal obligation. And I would argue that these acts of defiance are actually consistent with the moral interpretive approach, as long as we still have a world where there aren't institutional arrangements comparable or analogous to those of a fully developed liberal democratic state. The Cadi case, where the European Court of Justice essentially said that the European authorities could not implement a terrorism financing blacklist that was required by a UN Security Council resolution without having some kind of review mechanism of where people could appeal their name being on the blacklist. And the European Court of Human Rights said that even if it's implementing a Security Council resolution of the United Nations, which is binding under the UN Charter on members of the United Nations, European authorities still have to respect the fundamental principles of human rights, which are part of the fundamental principles of the European order. Now, that's certainly a moral interpretive approach, but it seems here to yield a tension with positive international, obligation. But I think that tension is ultimately, in a way, an implication of Ronnie's theory here. Unless we get to a stage of world government, a regional or domestic court would simply be compelled, in applying a moral interpretive approach, not to decide, in a way inconsistent with the political morality that grounds the undertaking of international obligation in the first place, and therefore might have to defy a valid positive act of the international instance. And the second example, more recent and perhaps even more debatable, and troubling to classic positivist international lawyers, is that the Italian Constitutional Court refused to yield to a decision of the International Court of Justice on sovereign immunity in Germany v. Italy, a very Westphalian decision based upon traditional concepts of sovereign equality. And in that case, what was involved was that Italian victims of German massacres and other atrocities during World War II were suing Germany in damages for reparations. And the International Court of Justice said there's a customary international law norm of immunity that bars such lawsuits, and that Italy had, and its courts, was required to comply with that norm. And so the Italian Constitutional Court said we can't, because it's a fundamental aspect of our constitutional order that victims of these kinds of wrongs have enforceable legal rights in that constitutional order. And so again, there's a defiance of positive, a valid positive act of an international instance, in the sense that the court's decision was clearly binding as a matter of international positive international law on Italy. But the Italian court said no, we cannot be bound by even a valid positive international act that's contrary to fundamental principles of our constitutional order. And I think if they were applying Ronnie's moral interpretive approach, that's exactly the conclusion that they would have had to come to, based on the principle of salience and based on international legal obligation ultimately being derivative from internal political morality.
Thank you, Roberto.
Thanks.
Giulio, sorry.
Thank you very much. So that's the final title of my presentation, Unpacking Human Rights. This is really work in progress, so I will be really happy to hear your comments and suggestions. I would like to start with two evident facts about human rights. The first evident fact is that human rights are a flourishing social practice. Since the Universal Declaration of Human Rights was adopted, almost every single nation state has joined human rights practice, and it is now composed of hundreds of treaties, courts, and international bodies. The second evident fact about human rights practice is that it is an interpretive practice. And this is so because although its participants agree that it is a valuable activity, they nevertheless deeply disagree about its constitutive rules and the true nature of the goals it intends to serve. So for example, some authors think that human rights, next one please, some authors think that human rights are norms aimed at preserving certain key features, capacities, or interests of human beings from the activities of all other agents. From this perspective, human rights are claims that human beings have against governments, international organizations, transnational corporations, and even other individuals. This view is known in the literature as the natural rights approach to human rights. On the other hand, other authors think that human rights are norms playing a particular functional role within the current system of states. And this role is to trump national sovereignty by justifying international sanctions when governments violate the interests that human rights protect. This view is known in the debates as the political approach to human rights. So in Justice for Hedgehogs, Dworkin rejects both accounts of human rights, arguing that they fail to satisfy the conditions for interpreting social practices stated by constructive interpretivism. And he suggests an alternative understanding of human rights. According to this understanding, human rights are norms protecting human dignity against contempt on the part of governments. There are two main theses I want to defend along this presentation. The first thesis is that the contempt account is an unsuitable interpretation of contemporary human rights, and I think it is an unsuitable interpretation of contemporary human rights because it fails to justify some of the main characteristics of current human rights practice. The second thesis I want to defend is that human rights are not a monolithic practice sorry about that. It's not a monolithic practice as Dworkin and many other authors appear to think. It is rather a complex activity combining different components which deal with distinct moral concerns. So this is the structure of my paper. In the paper I start by reviewing the conditions that any decent account of a social practice ought to meet according to constructive interpretivism. I then assess the three rival conceptions of human rights I have just introduced. In particular, I try to show that the contempt account is misleading because it overlooks three decisive aspects of contemporary human rights practice. And finally, I suggest an alternative account of contemporary human rights to which I refer as the pluralist account. I assume that you all know the three stages of constructive interpretivism, so I will skip this presentation, this slide. I just want to remind you that there are two general constraints that any reasonable account of a social practice ought to meet according to constructive interpretivism. The first general constraint is justification, and this means that the proposed interpretation must present the practice as serving a genuine moral goal. And the second general constraint is fit with the practice. And this entails that the proposed interpretation must manage to accommodate the most salient features of the practice as we now encounter it. Of course, no account of a social practice can accommodate all the material identified in the first stage of the interpretive process. However, unless it succeeds at accommodating a reasonable amount of this material, it will be relevant to the practice and may lack theoretical authority over it. In the case of human rights practice, I think that this means that any reasonable conception of human rights must help us understand why human rights include many of the rights proclaimed by present human rights doctrine, why human rights are considered to be universal and to derive from the intrinsic dignity of the human person, and why they may be used as standards for assessing the behavior of governments. So let me very quickly tell you what Dworkin thinks about the natural rights approach. Dworkin thinks that the main problem with the natural rights approach is that it cannot justify human rights practice on genuine principle grounds. Let me explain you why, if I can. As I have already explained, this view understands human rights as norms protecting certain fundamental interests of human beings. And Dworkin thinks that most political rights serve this very same goal. So consider, for instance, the right to a fair share of the income produced through social cooperation. This right is no doubt fundamental, as income has a determining impact over life prospects. Or consider instead the right to same-sex marriage. What can be more fundamental for human beings than being able to marry the person we love? In view of considerations like this, Dworkin concludes that any attempt to define some more fundamental layer of rights by reference to its substantive content is unavoidably arbitrary and doomed to fail. So let me now tell you what Dworkin thinks about the political approach. He thinks that the main problem with the political approach is that it fails to fit current human rights practice. And it's easy to see why. In view of the immense suffering they inflict on the population of the target state, international sanctions are justified only to stop truly barbaric acts, such as massive murdering, savage discrimination, torture, what means that most of the rights proclaimed in present human rights doctrine would not count as real human rights according to the political approach. So the view that Dworkin suggests is certainly more promising. Dworkin proposes to understand human rights as norms deriving from a more abstract rights, and this is the right to be treated by our government as a human being whose dignity fundamentally matters. As you know, Dworkin thinks that we can make sense of the value of dignity by reference to two complementary principles. The first principle holds that each human life has an intrinsic value and that it therefore matters how it goes. And the second principle holds that each person has a special responsibility for realizing the success of her own existence by making a judgment about the kind of life that would be good for her. So this second principle protects our autonomy as individuals. It is evident that these two principles of dignity can be interpreted in different ways. And this is why different political communities may hold alternative interpretations of what full respect for human dignity amounts to. And this is also why they may have alternative conceptions of political justice. However, not everything is up for grabs. Dworkin thinks that some behaviors are so egregiously wrong that they cannot be justified as a good faith attempt to treat people as human beings whose dignity fundamentally matters. So, for instance, a government that supposes that some people are inferior, or that condones assassination, rape, or torture, clearly violates the first principle of dignity. And a government that fails to recognize rights to freedom of expression, freedom of conscience, and political participation violates the second principle of dignity by denying those in its power a chance to take responsibility over their existence. There is a final point I want to mention, and this point is that when a government assumes this attitude, when a government shows contempt for the dignity of human beings, it enjoys no genuine authority over them. What means that when governments behave in this way, people can protest, engage in civil disobedience, or even seek to overthrow them. What means that at the end of the day, the value that lies at the heart of the contempt account is political legitimacy. So let me tell you what's wrong with the contempt account, if I may. I think that the main problem with the contempt account is that it overlooks three decisive aspects of current human rights practice, and as a result of this, it fails to justify some of its most salient characteristics. So the first aspect has to do with the criterion for identifying human rights. As Dworkin himself recognizes, present human rights doctrine recognizes an expansive set of rights, including rights to marriage, housing, education, social security, maternity leave, due process, equal pay for equal work. And I think it is evident that a government that neglects these rights does not become illegitimate or show contempt for the dignity of human beings for that reason. It may simply endorse a good faith, misleading understanding of what respecting human dignity requires. In fact, when international courts blame states for violating human rights, they normally do not mean that these states are not legitimate any longer. They simply mean that for some reason the policies, laws and regulations they have adopted are inadequate. I think that all of this suggests that human rights are not about preventing bad faith on the part of governments or about preserving the conditions for political legitimacy, as Dworkin thinks. Rather, current human rights practice appears to try to identify and correct mistaken interpretations of the true principles of human dignity we have just considered. The second aspect that the contempt account overlooks refers to the scope that human rights norms are considered to have under present international law. The contempt account regards human rights as norms regulating the treatment that governments may give to their residents. However, according to most international lawyers, the role of human rights norms cannot be reduced to this sole function. And this is the reason for this is that they play many other human rights norms play many other relevant functions. So, for instance, they constrain the activities of quasi-state agents, including occupation forces, guerrillas, or armed groups in control of a territory. They restrict the conduct of states acting across borders, and this is why, for example, no government can sell weapons to a foreign dictator knowing that the dictator will use these weapons to oppress the population. And they also are meant to provide guidelines for criticizing and reforming global governance institutions. So the third aspect that the contempt account overlooks has to do with the international dimension of human rights. Although there is agreement among experts that the main responsibility for fulfilling human rights falls on governments, under current international law, the international community nevertheless bears explicit obligations for the universal satisfaction of human rights. So here are some examples of how the principle of international cooperation of human rights pervades current human rights doctrine. And many authors actually think that the principle of international cooperation for human rights is one of the cornerstones of contemporary international law. And the problem with the contempt account is that by understanding human rights as norms simply regulating the treatment that governments may give to their residents, it fails to account for these absolutely outstanding aspects of contemporary human rights practice. Of course, as Dworkin says, if people are massively murdered or heavily oppressed by a dictator, other nations may have an obligation to rescue them if they can do so at a reasonable cost. However, the principle of international cooperation for human rights requires much more than this. It requires that the international community monitors the activities of all governments, that it deters its members for contributing to human rights violations abroad, that it prevents global governance institutions from undermining human rights satisfaction, and that it takes proactive steps to progressively improve the capacity of poor societies to fulfill the human rights of their residents. I think it is now time to, in 5 minutes, present an alternative account of human rights. As I have already said, I refer to this account as the pluralist account of human rights, and the main idea of the pluralist account is that human rights constitute a complex social practice combining three complementary components. And although these three components aim to promote a same overall goal, they nevertheless point to distinct moral concerns, involve different moral relations, and have alternative normative roots. So I will very quickly introduce what's wrong with that? Okay, so I will try to very quickly introduce these three components in turn. So the first component of contemporary human rights practice 22, please. I'm sorry. So the first component of contemporary human rights practice articulates the conditions that agents wielding sovereign political authority ought to fulfill in order to treat their subjects or those in their power with the minimal concern and respect they deserve as human beings. There are two particular aspects of this definition I would like to clarify. The first aspect has to do with the notion of sovereign political authority. By sovereign political authority, I mean any agents with the authority to make final decisions regarding the distribution of primary goods among members of a human community, and this is why human rights standards apply or would apply to occupation forces, guerrillas, or armed groups in control of a territory, but would not apply, at least in principle, to transnational corporations and individual human beings. The second aspect I want to clarify refers to the notion of minimal concern and respect. So in my view, human rights are not, they are neither conditions for political legitimacy nor conditions for full political justice. They are rather, they articulate a minimal conception of justice for domestic institutions, so provided governments satisfy this threshold conception of political justice, they are free to implement more demanding conceptions of justice or to promote whatever collective goals they may want to promote. So the second component of contemporary human rights practice is of a different nature. It expresses conditions for the legitimacy of an international order sanctioning the existence of a system of states. In particular, sanctioning the existence of a system of state which recognizes government sovereign political authority over their populations. As long as this order is coercively imposed on nations and human beings, it calls, of course, for a moral justification. And I want to suggest that such an order is justified provided two conditions obtain. The first condition is that the international community must look after the realization of human rights everywhere by monitoring the activities of governments and imposing progressive sanctions on those unwilling to satisfy human rights. Otherwise, the sovereign authority the international order recognizes to states would constitute a permission to hamper the dignity of human beings. The second condition is that the international community must prevent states and international institutions, including, of course, global governance institutions, from contributing to human rights violations abroad and from illegitimately undermining the capacity of governments to fulfill the human rights of their residents. Finally, the third component of contemporary human rights practice refers to what sovereign political communities have agreed to do for each other under current international law. And what they have agreed to do for each other is to take proactive steps to progressively enhance the capacity of all nations to deliver on human rights. And it's important to bear in mind that this is not a matter, it's not a conceptual matter, it's not a matter of conceptual morality, it's just a matter of positive law. The reason the international community must behave in this way is because it has promised to behave in this way. So it is important to note that these three components contribute to a same overall goal. And this goal is to ensure that political authorities treat those in their power with the concern and respect they deserve as human beings. However, they contribute to this goal in specific ways. They have distinct moral sources and involve irreducible sets of obligations. This is why, if any of these three components is neglected, a whole aspect of contemporary human rights practice becomes unintelligible and impossible to justify. And I think this is what happens to the contempt account. Well, of course, I think that my view satisfies the two general constraints for interpreting social practices laid out by Dworkin. So these are my three concluding remarks. First, the contempt account is vulnerable to the same objections Dworkin directs against its rival views. The second remark is that current human rights practice is a complex activity composed of three complementary modules. Therefore, interpreting contemporary human rights practice involves understanding each of these modules, making decisions about what they require, and explaining how they combine and interact. And finally, even if you find the details of the pluralist account I have just suggested partially unconvincing, you may still use it as a general, more fruitful framework to produce your own conception of human rights. And if you wonder what Ronnie would say about the pluralist account of human rights, well, here is the answer. Thank you very much for your attention.
Thank you. We have two very rich and refreshing perspectives on the issues raised by Ronnie's last essay. I think both of our authors here are agreed that Ronnie's state-centric view of human rights and international law is inadequate. It just doesn't do the job. And I concur with that, and I won't go into the additional reasons why. So where do we go from there? And as I understand it, Rob is the view that we need to develop a international conception of international law and an international normative order that has its own distinct norms that may be different from those prevailing within states, and they have to be shaped and refreshed by some sort of a dialogue or dialectic between international organs, courts, I would say administrative bodies, other institutions, and domestic institutions, courts, but also other institutions. Whereas Julio has his pluralist view of human rights, as I read it, suggests that, well, the same basic framework, normative framework, can apply both domestically and internationally, right? So I think that's, as I read it, a pretty significant difference. I'm glad, I know this is explicit in Julio's paper and remarks today, and much work that Rob has done, that the challenge here is not just the behavior of states, but the behavior of an increasingly dense array of international institutions or global institutions. The demands of globalization, the intensity of globalization has created demands for various forms of regulation, coordination in the security area, in the economic area, and now in areas of moral ends, social, environmental, human rights. And we see a great array of very disparate treaty regimes, networks of government regulators, private regulatory bodies, private public regulatory bodies with some state or international organization participation. And each of these has their own, we might say, normativity, their own purpose. And as Rob has sort of indicated briefly but convincingly, these can't be regarded as mere deals. These are ongoing institutions that have their own purposes. And the issue then is, well, with what general normative framework all of this global governance is operating, and then how does it relate to the conduct of states? And it seems to me that's the challenge we face. The states are still very important, but the intensification of globalization will continue, and the greater density of international institutions of all sorts. The nation state has only been with us roughly 250 years. It will be in a process of continuing transformation, and so we have to bear that in mind, and that makes me all the more in agreement with the basic, with the critiques, somewhat from different perspectives of Dworkin's account here. Just a little bit on then what our two presenters would do to deal with this need. For Julio, I think your rejection of human rights is only against national governments or state governments is convincing. I think your critique of Dworkin's notion of dignity as a sort of a master key is, well, it has to be unpacked and grounded more. And I think you come up with some very intriguing. Your five notions are very intriguing, and so you would apply these both domestically into the international order. I guess one question or difficulty I have is that you have, this is a sort of constructivist interpretation that's based on practice. And you say human rights is flourishing, but as Rob points out, authoritarian governments probably rule at least 2 billion people on the planet. And I'm not sure when you say you're looking at practice, is the practice the discourse of rights? Even if it's discourse, I don't find you much discourse in my time in China about human rights. That's a subject that's off the table. And pretty much in Saudi Arabia or in the Gulf, in my experience. And of course, one might say talk is cheap. Shouldn't, if it's practice, the actual conduct of states be the criterion? And if that's it, I don't think you can support your ambitious claim of what the elements of the current situation of your pluralist human rights are. For Rob, I have just a question we'll have to pursue maybe on another occasion, whether the resources of positivism, at least of a Hartian view, are necessarily excluded. You have two candidates, following Ronnie, sort of contractarianism, right, contract and consent, or the notion of some Austinian institution, the Supreme Court or whatever, that's going to lay down the law. But there are purposes within the different global governance institutions that I've indicated. And
out of that evolution, is there possible to have sort of trans-institutional norms that are developed and recognized? My colleague Kingsbury and I have written on global administrative law, certain basic procedures for certain types of decisions. There seems to be increasing recognition that this has a binding or obligatory quality, at least in certain situations. So maybe there's a possibility of imminent development of certain norms that receive a recognition. I just put that as a possibility. I guess the other question I posed to Rob is that we can see the sort of a notion of a general normative order based on security and economic development. States are in favor of that, and we see a gradual thickening of other normative objectives. Environment, I've mentioned human rights, although intermittently implemented, and other social concerns. And I could give examples if we had time, but I will pass that by. And you see, I think you're seeing this interaction between domestic bodies of various sorts and global bodies as a way of potentially thickening that normative order, and that is done at retail in particular sectors of the global governance, as Rob has written on the WTO, for example. And so we see a sort of evolutionary and decentral approach within the decentralized order. But what about the dialogue with the authoritarian states? Will that occur? And with the rise of China, I just give one example. International development assistance through multilateral agencies, the World Bank and so forth. We have a very good system of social and environmental protections for projects that are funded by the World Bank and other development banks in developing countries. China is now becoming the big financer. They don't care about this. Will they displace or at least marginalize this developing order. So what is the challenge of authoritarian governments or of governments that do not share liberal democratic values, at least to the same extent?
Do you want us to respond?
Why don't you briefly, if you want, and then we can open it up.
Well, I think that, Dick, that last question is a really crucial one because one view of international law is that it supposes that as these regimes become part of a thickening international legal order, that there's almost there's a dynamic away from authoritarianism, but there's a kind of intrinsic tension between a great deal of the normativity of the international system as we know it today, and the maintenance of those kinds of political regimes. And so the question is, can we understand this as a creative tension, or ought we to be protective of a space of international legal normativity where we, as it were, treat those regimes or the states that are represented by those regimes as equal sovereigns, and have a kind of minimalist language of legality that might draw on these older Westphalian and positivist conceptions. And it's a huge issue. Just now in the debate about whether there should be a nuclear deal with Iran, and one view is that that Iran has placed itself outside of the effective world of international normativity by a range of its actions and positions, and therefore that unless that changes, or unless there's significant evidence of change, that one should not, that such an agreement would be based on a false premise that one can have a legal settlement of this kind with a regime that adheres explicitly to a set of values that seems so inconsistent with much of the normativity of the international legal order today. The other view would be that there's an important purpose, and I think it would meet Ronnie's salience criterion for having such an agreement, regardless of that, and we should orient ourselves by understanding that purpose, but always realize that the nature of such an agreement will not meet perhaps the ultimate aspiration we have for international legal normativity. But I think that the question is whether we introduce a tension that's constructive and dynamic, or introduce a tension that's destructive of international normativity by having international legal relations with such states, and between such states and other states that that have strong elements of liberal democratic morality, political morality, or are aspiring to get there. But I think the question of whether there's a possible normativity at the international plane itself, this is something that Ronnie avoids in the essay. And of course, in my paper, I suggest that one way of dealing with this issue of the incompleteness suggested by the salience view is to say there is at least a minimalist international morality, and that's the cosmopolitan idea, or the Ruchi Teitel humanities law idea, that there actually are certain rights and obligations that human beings owe each other, regardless of being fellow citizens within a particular political community. And so one could employ a moral interpretive approach simply at the international plane if one were to be grounded, or to ground the moral interpretive approach on that kind of morality reality of, of humanity that doesn't seem to be dependent upon prior associative obligation. But the question is how far one gets, in the sense that, I mean, how many international legal norms really ultimately can be grounded in those obligations we could really persuasively argue human beings owe one another regardless of association within political communities. And certainly, the prohibition on torture might be one, prohibition on genocide, and then, certain other human rights. But how far out can one go without becoming somewhat unpersuasive, or where the obligations become too vague unless they become defined through representative institutions within particular constitutional regimes?
Thank you. Julio.
So I think your question was, what do you mean by human rights practice? Where is the practice located? Well, we have lots of treaties, international documents, lots of courts, the European Court of Human Rights, the International Court. We also have a human rights discourse, and if we care about what states do, well, I think that in 1940 there were just 12 democratic states all over the world, and the rest were authoritarian regimes. These days, a good amount of states are democratic. 20 years ago or 50 years ago, massive killings going on in other countries were not our business. They were not our problem. These days, we even care when governments suppress freedom of expression, and I think this shows an increasing commitment with human rights on the part of the international community. So the challenge is trying to understand what's going on there, what the heart of that increasing commitment is, and producing the kind of theory that may reinforce that commitment and help us understand what we are doing when we engage in human rights practice.
Thank you. Thank you both very much. Yes. Eduardo.
Lost. I'm sorry. Could you point?
Thank you. Thank you very much for both of you for the presentations, but my question goes to Julio. I think in your paper, which is a very good paper, I think there are two things that I would like you to clarify and elaborate a little bit. First thing is the idea that human rights is a practice. When you're saying human rights is a practice, I can understand that as long as I understand that human rights is a branch of the law, it's constitutional law or international law, then of course human rights in this respect shares the nature of right in general, of law in general, according to Dworkin, and then it would be an interpretive practice. I understand that. But I think in your paper you make arguments that go in a different direction. So there are two things in your paper. That's what I want you to clarify. The other thing is, when you give Dworkin's arguments about the foundations of human rights, then what you are discussing is the nature of those rights within the idea of human rights. I don't know if I make myself clear. So you're discussing, the discussion would be, are human rights, civil rights, fundamental rights, what's their category? Depending on their category, justifications are different. When I read your paper, I was thinking of the big distinction that Pufendorf makes among what he calls absolute rights and hypothetical rights. Well, hypothetical rights you have depending on the political community which you belong to. You may have one right or another right, and depending on the what he calls the negócio jurídico, the business you enter into. It's not an absolute right. You have absolute rights independent of any business you have or any political community you belong to. Do I make myself clear? I think you're discussing two different things. I don't disagree, but I think you have to make clear why you start talking about human rights as a practice and then goes into what in my opinion is a different thing, is the justification of rights as human rights, not as political rights, fundamental rights, civil rights. That's my point. Thank you.
Well, I certainly think that human rights is it's a practice. It's a concept associated to a practice. So what we need to understand is what is the criterion for identifying a certain set of rights as human rights. One possibility is to read, philosophical texts. Another possibility is to try to understand what we do when we engage in human rights practice. And my impression is that when we have a look at the practice, in order to qualify as a human right, a right must be part of what a political community owes to individual human beings in order to treat them in a fair way or with the concern and respect they deserve as human beings. But I think that is the response. So I start with the practice and I try to understand what kind of rights qualify as human rights according to the standards assumed, presupposed by the practice. And this is what I find. I find that it appears that a human right, that any right is a right if it is fundamental for protecting certain fundamental interests of human beings, which were not included in the presentation but are available in the paper.
So, Jacob?
Okay, so Julio, I have a question about the nature of your pluralist account, and in particular, the relationship between the different conditions that form the account as a whole. Now, on page 15, you criticize authors who conceive of human rights, as you put it, as stemming from an agreement voluntarily undertaken. And I think you rightly point out that if human rights are conceptualized in this way, they then become dependent on historical events, which are completely contingent. But we think of human rights as something inhering in human beings, and so there's a basic tension there. But then when you're outlining the conditions that cumulatively comprise your theory, you write on page 21 that by signing human rights documents, nations have voluntarily undertaken responsibility to take proactive steps to achieve human rights all over the world. So I'm not sure that I understand what your stand is with respect to the source of the obligation that human rights impose on states. If it's a conventionalist account that there's some contingently undertaken act that generates the obligation, then it seems that you are going to fall victim to your own criticisms of other theorists. And there's also going to be not a pluralism, but an incoherence between your first condition, your first component, and your third. Because your first component is just recognizing that human dignity entails certain rights, and you conceive of human dignity, I take it, to be inherent. And so I just wanted you to clarify the nature of the account. Are you rejecting conventionalism as such with respect to the source of human rights, or with respect to some conditions and not others? And if it's with respect to some conditions and not others, how is this pluralism as opposed to an incoherence between the conditions?
Thank you very much. So human rights have several components. The first two of them are conceptual. They are timeless in a certain way. So states would have an obligation to fulfill human rights even if there were no international community or international law. Then there is another component of human rights practice which has a positive nature. However, they are two separate components, and the first component would exist even if the third component was absent. So it's like having an obligation and then making a promise to fulfill that obligation in a particular way. That's what's going on here. So if we had no international community, no international law, states would still have an obligation to fulfill human rights. However, the international community may not have an obligation to undertake proactive actions to promote human rights satisfaction all over the world. So that's the point. This is an obligation the international community nations only have because they have freely undertaken the commitment to behave in this way. This is the most fundamental part of the Charter of the United Nations, I think. We are not separate nations anymore. We now constitute a true community of peoples with common values. One of our values is promoting human rights, and in order to promote human rights, one of the things we are going to do is we are going to take steps to improve the capacity of states to fulfill human rights demands. So this is a matter of positive law. The other part of the practice, which is, I think, in a certain way, the core of the practice, is conceptual. It's timeless. It is universal, and it derives from the intrinsic dignity of the human person.
Carlos.
I think he was not satisfied with the answer.
My question is for Julio. Julio, I mean, I think what Rick said is an important point in the sense that what kind of practice are you talking about? And you said, no, well, listen, we care if a film is prohibited somewhere in the world, but that's not enough, isn't it? I mean, when we talk about the legal practice, a domestic legal practice, we're talking about institutional settings that somehow determine the way in which we act and think. You could say it would be great if the international community care about violations of rights, and we lawyers connected with the human rights movement around the world care about the violation of rights. But the question is whether violation of rights contradicts directly international law. So, in a way that we are forced to respond as we would do so in the domestic area. Because when you said, Rick, I think will suggest, well, when you talk about practice, you're talking about talk. It's just discourse. And you know, if somebody says it's as a matter of law, as a matter of international law, what China is doing is illegal. And I think if we want to mean something by that, something should follow. Either we should act, we should bring China to court, but we don't do that. And I think people will laugh if you say we want China in a court of justice or Venezuela, or we just don't do that. So one thing is the aspirations we may have to form an international community, that it's also a legal community. Another thing is whether we already have a factual and institutional setting required in order to talk about a normative practice.
I think you're too pessimistic. So we have lots of monitoring bodies, monitoring the conduct of governments, asking for explanations, and exposing governments when they fail to satisfy human rights.
Obviously, we have a discourse community. It's a world seminar, no doubt about it, and we care about violations of human rights all over the world. But the question is whether, when that happens, it's against international law. And more than that, when that happens something very similar to the same violation happening in domestic area. Because you can use the words as you want. The question is, when that happens domestically, we know how to react. When it happens internationally, it seems that we don't really react in the same way. So something must be different. Practices seem to be different.
I don't see why we should react in exactly the same way. So if my government, which speaks in my name, tortures my neighbor, my responsibilities are not the same that would be if China tortures those in power of the Chinese government. However, human rights practice is not just words. So the Charter of the United Nations, the Universal Declaration of Human Rights, the International Covenants on Human Rights, this is law. Don't you think this is law?
What do you mean by law there? I mean, it's different.
Well,
it's a different thing somehow.
It's a different kind of law. It's international law, not domestic law. And what we should try to do, according to constructive interpretivism, is try to understand what are the aims this particular kind of law is trying to preserve, and then propose reforms of the way the practice works in order to better serve, to better achieve these ends. So I agree with you that governments are not doing what I say they should be doing, but that does not mean that they don't have an obligation to do it. They do have an obligation to do it. The reason why they have an obligation...
It may be so. The question is whether they have an obligation out of the practice. I mean, it may be so that we have international obligations, okay? But your point is not only that. Your point is that we have that because we have the practice. So that's a problematic aspect of the idea. In the domestic area, it seems that the practice somehow founds obligations. It's okay.
No, well, I think I'm really Dworkinian about this. So I think that the practice serves a goal which in a certain way is independent of the practice. The reason we have this practice is because it is valuable to make it sure that sovereign political authorities treat human beings in certain ways. So if there were no human rights practice, I would advocate in favor of creating such practice just because I can perfectly understand the values that the practice promotes. So in a certain way, I don't think the normativity of the practice is completely dependent on the nature of the practice, on the reality of the practice.
I really like your account of international law, much more than the usual ones, but I find that even at the normative level, there's a long list of conflicting, vague rights that you cannot accomplish altogether. For example, China might say that he's accomplished the human right of development, and because of that, he's at the same time violating I don't know, so many, for example, of good condition at work. I mean, I cannot even want an expression of desire that is not included in some legal documents. So it's not clear for me how are you going to distinguish, even as a practice or even as a norm in the normative aspect, which is a human right and which is not. Well, for example, in the case of China, how are we going to decide this? If it is a practice, we know how to decide it, but also, because as Carlos was saying, for example, we don't have a meta-criteria to recognize when we're in front of a human right or when we're just a political aspiration, which for me are very good for enhancing welfare and a different aspect, very valuable goals. But this very vague, long and conflicting goals.
That's a very good point. It's very hard to explain what makes a right a human right. Some people think human rights have to do with autonomy. Other things that we have to try to understand the functional role they play within contemporary political life. Dworkin think it is about showing contempt for the dignity of human beings. I have my own account. In the paper, I propose. So, if you have a look at the Universal Declaration of Human Rights, you can find there a certain conception of the human person. You can find the conception of the human person as a free, equal, and autonomous agent. And I think that by generalizing from the interests that the International Declaration seeks to protect, we can kind of propose a list of abstract rights that express high-order interests of human beings. So, and these include different kinds of interests, like interest in security, in an adequate level of living, in not being exploited. So it's a big bag of interests. But I think this is a fair way of trying to define criteria that may help us distinguish human rights from other kinds of political rights.
So, Marissa, you have the last question.
My question is for Julio. Well, I'm not sure because what are you trying to do is to defend a conception, a characterization of human rights. Is to try to figure out when a right, becomes a human right. This is so, no? And then it seems that the three components you are using, only the first is conceptual. No, it seems that first, if we are asking what is human right, we are going to say that, well, this is a right that any human right has for its humanity due to human dignity that everybody has. And the second and the third one, the second is related to, well, why the international order should be involved in the protection of human rights, since the international order is what makes possible for a state sovereignty and the control of its population, then you acquire an obligation. And the last one is saying, is like something like motivation. Maybe it's possible to ask to the international order because, in fact, the states are motivated to do that because they have agreed to that. But my problem is, what is the difference as a characterization of human rights? What is the difference of your view and natural law view? And I'm not sure of that yet, and it's my question. But this is, for me, it's important because if we are going to undertake or assume political characterization of human rights, we are going to assume a dualist conception of human rights. And the contrary conception is a monist one. If we assume an ethical conception or a natural law conception, well, we don't have reason to say that human rights are a question of state protection only. Everybody should have an obligation to protect human rights because dignity is a base strong enough to generate duties on others. But the practice of human rights is not a practice related to what everybody has to do concerning the protection of the dignity of people, because of the humanity they have. Then the practice is related to the justification of international action or the justification of limiting state sovereignty. And I don't know how your conceptual assumption that is only the first component of the three components you are working on is going to make it possible to focus only on the idea of the duty of the state to protect the dignity of people.
That's a very good and long question with many sub-questions in it.
And you're going to give a very short answer.
Okay.
Because we're at the end of our time.
Okay. So, well, I think that the main difference between my view and natural rights, traditional natural rights approaches is that I think that human rights are rights basically against the state or against governments, and the reason it works in this way is because this is what the practice is about. So I start by having a look at the practice, and I find something valuable in the practice, and what I find distinct and particularly valuable in the practice is that it protects our interests from an agent wielding, administering a unique kind of power. No other agent on earth claims the kind of authority that sovereign authorities claim over human beings. So we need a special category they have special responsibility towards human beings because they claim this unique kind of power, and when they fail to live up to these responsibilities, they commit a unique kind of moral wrong. And we need a name for that kind of moral wrong, and the name we have is a human rights violation. So this is what makes my view in a certain way different from natural rights approach. Having said this, I think that my view has naturalistic grounds for human rights. Just to mention, just to tackle your second comment, I like traditional political approaches, but they have terrible problems. They entail that if the international community ceased to exist, we would have no human rights any longer, and that can't be true.
All right, thank you. Both of you join me in thanking our presenters. There's coffee outside.
Excellent.
So have a good trip.
Thanks a lot, and those are very interesting.